Good afternoon. Welcome to everybody. Thank you so much for joining us today for our first of our Title IX team lunch meetups. Today, I'm pleased to be joined by two other members of our Title IX team here at Franczek, Jennifer Smith and Jackie Worms.
Hi, I wish that my hair still looked like that. Just realizing how bad it looks, but okay, let's continue.
Hi, everyone. I'm Jackie. So for those of you who may not know, we started these Title IX team meetups over the summer to offer a place for administrators who are working with Title IX and also practitioners to meet and raise and discuss questions arising in the field as they were working their way through implementing the new Title IX regulations. And although we did stop our Title IX team meetups, we stopped after the August 14th implementation date because we knew we all could use a break. But we heard from many of you that you had found these meetups to be valuable and that this was a good chance to think through Title IX issues with your peers and with your attorneys at Franczek. And so we're excited to bring this back in a new format. So we're going to meet monthly on the first Tuesday of each month from 12:30 to 1 p.m. We heard from many of you this summer that you wish that the meetings would be recorded. So we are going to be recording this. We've switched over to a webinar format for that reason, so that we can record and share the meetings. So you can ask Q&A through the Q&A function on Zoom, which should be at the bottom of your screen on the toolbar. You can ask questions anonymously. So we are hoping that this will help strike the balance of offering a safe place to ask questions with the need to make sure that this programming is accessible to all of you in light of your busy schedules. You should make sure to sign up for our alerts at franczek.com/subscribe so that you receive notice of these team meetings as well as all of our other thought leadership and insights that we offer to our clients and friends. Please make sure to check out the many materials we have posted on our blog. So we have a blog at title9insights.com. So you also should head over there and check out what we have available. And then also we've added a link here to our Title IX YouTube channel. You can find all of our recorded webinars on our website at franczek.com/events. But you also can subscribe to our YouTube channel to receive updates when new Title IX material is posted there.
Okay, so we don't have a ton of time together today, so we have a short agenda. We're going to start with a very quick refresh of the elements of the Title IX regulations that are being discussed today. We're going to focus most of our time on the Title IX Big Five, and then we'll leave some time at the end for any questions that you have that you want to discuss today.
So first we have a quick refresher on what's new with the Title IX rules coming into effect. So this is a summary, a good overview. A school violates the new Title IX rules when there is Title IX sexual harassment, we're going to talk about that a lot, occurring in the United States, and the student or the school has substantial control over the context of the harassment and the harasser, which in other words means that the sexual harassment occurred in a program or activity of the school. There also has to be actual knowledge of the misconduct by an official with authority to institute corrective measures, which for K-12 means all employees. And the school must be deliberately indifferent, meaning they act clearly unreasonable in light of the circumstance. That can include a failure to use the right procedures in the complaint, which we now know are very prescripted in the new regulations.
So our discussion today, as Jennifer mentioned, is going to focus on sexual harassment, and specifically what many are calling the Title IX Big Five. So you might be wondering what that is. If you've gone through the Franczek Basic Title IX training, which hopefully all of you have or will be soon, you will remember that the new Title IX regulations define sexual harassment as either employee quid pro quo, conduct creating a hostile environment, which has a new, more narrow definition of that, what we usually refer to hostile environment, sexual harassment, and then the big four types of sexual harassment under the Clery Act and the Violence Against Women Act.
Okay, so what are the Clery Act and the Violence Against Women Act, or VAWA? You may know the Clery Act typically applies to higher educational institutions, involves collecting and reporting data about crimes, and the Violence Against Women Act you may also be familiar with. So the definitions come from those acts, and then those acts kind of reference other statutes as well, and it can get a little bit complicated. So the citations you see here are to VAWA, and that's what you'll see in many policies. It's just a reference to the citations as opposed to really spelling out exactly what they mean. And the reason for that is because, like I said, the definitions sort of cross-reference different statutes, and if one of them changes and you have in your policy a definition that was the prior definition, then you're going to be scrambling to make a change to your policy. So it can be a little bit confusing. We're going to talk through our best understanding of what each of these mean: sexual assault, domestic violence, dating violence, and stalking. And then we do recommend that you have definitions, working definitions in your administrative procedures so that your Title IX coordinator and people who are conducting investigations or who are decision makers have that as a reference to use. Ultimately, your Title IX coordinator and your team should be working with legal counsel to make sure that you're using the most up-to-date and current definitions of these terms.
Yeah, and for those of you who are in it,
or Jackie.
Go ahead.
Oh, before we go on, we've worked with so many clients now on these definitions, and Kendra, you mentioned sometimes the advantage of including the statutory references as the definition is that you're not in a trap if one of the references changes. We've heard from clients, though, that to the extent their policies are an education piece to their community, just including these sites is extremely unhelpful in actually defining these terms for your community. So there's definitely a balance to be struck here on accuracy and not constantly updating your policies when things change versus actually telling people what's prohibited in a way they can understand. So just wanted to give those two competing interests right now, given the challenges of defining all these terms.
Right, and so I think some schools and school districts, colleges, universities are striking the balance by maybe keeping the language in their policies a little bit, not vague, but just referencing the statutory provisions, but then they might look to their administrative procedures or their websites to include more information, clearer definitions. And so, for instance, for those of you who are Illinois K-12 school districts and are using press policies, they do have an administrative procedure. They call it an exhibit that doesn't become part of your board policy handbook. It doesn't get posted online as part of that, but that is available for your team to use and to rely on when looking for these definitions. And you do always have the right to post those exhibits and administrative procedures on your website as well. So most of our higher education institutions have very extensive websites that address Title IX. I think a lot of our K-12 schools are starting to move in that direction. And so I think, again, trying to kind of figure out how you want to strike that balance and where you want to end up may be determined by what options you have available for communicating with your community on these terms.
Great. So then what is the Title IX Big Five when we talk about that? If it's not a term that you'll necessarily see in the statute, but it's something that is kind of becoming shorthand for all these different buckets of conduct. So when we talk about the Title IX Big Five, we are talking about essentially the different buckets of content that do not require the hostile environment analysis under the new regulations. So that's the employee quid pro quo, sexual assault, domestic violence, dating violence, and stalking.
That's right. And so other than those big five offenses, you will always have to ask whether the reported conduct was so severe, pervasive, and objectively offensive that it effectively denies equal access to your school's program or activity to the complainant. But for the big five, you don't have to find that the conduct was severe, pervasive, objectively offensive, or that there was an effective denial of access. Conduct that meets those definitions will automatically be considered Title IX sexual harassment for purposes of determining what procedures should be used to address a report or a complaint.
All right, so let's walk through these Title IX Big Five. And we'll start with employee quid pro quo. So as it's defined in Title IX, we're talking about an employee of the recipient conditioning an aid, service, or benefit of the recipient on an individual's participation in unwelcome sexual conduct. And like we've said in our other trainings, this only applies if the person initiating the quid pro quo is an employee, not a volunteer or a student. And like we said on the last slide, we are going to presume the severity and the harm. You don't have to go through that hostile environment analysis if it is quid pro quo on, initiated by an employee.
So to give an example, kind of the traditional example would be teacher saying, if you perform a sex act, you can get an A in my class. You know, that's an employee offering a benefit that they can offer because of their official position for a sex act. And remember what we're saying about severity, the hostile environment terms not being applied. So this could be no matter the severity. So that is what I just proposed as a very severe incident, but maybe even something more a minor touching, maybe that's not quite so sexual, would also get into the category of Title IX sexual harassment because we don't have the severity criteria on this one. So it could be, you know, asking for a shoulder rub in order to get extra help, or hey, if you rub my shoulders, I can help you with that assignment. That actually might fall into quid pro quo, even though it sounds a little more benign than, you know, the other example.
Yeah, and the key here is that this conduct needs to be by an adult in order to fall into this definition. Of course, that does not mean that if you have a report or a complaint of quid pro quo on a sexual basis by a student or by a volunteer or another non-employee that you're just going to ignore it or that it isn't going to fall under Title IX. It just means that you're going to use your hostile environment analysis to determine severity, pervasiveness, objective offensiveness, and denial of access before deciding that the definition of Title IX sexual harassment is met by the conduct. All right, so the next definition that we're going to talk about is sexual assault. And for these, we're calling these the, you know, Title IX Big Five, but for these that fall under the VAWA and Clery Act Big Four, we're giving you sort of the by the book definition that we were able to retrieve, and then we're following that up with a little bit more commentary on what our thoughts are on it. So as far as the by the book definition for sexual assault, it's not super helpful because it says that it does say forcible or non-forcible sex offense, but then it refers to the Uniform Crime Reporting System of the FBI, giving you citations and appendices to go look at for more information there. And we've included that, but you know, it does say rape, fondling, incest, and statutory rape. And Jennifer, I know you've thought a lot about this specific definition, so I don't know if you have any thoughts on kind of the the state of the statute and the language that it gives us here.
Well, yeah, we've gone down the rabbit hole on, there's actually, to make this even less helpful, what Jackie put up, there are 2 different FBI handbooks, and one of them has what's kind of known in the field as a more preferred modern definition of sexual assault, but that handbook is expiring in January. And there's another handbook that will continue to be the handbook after January, but many find its definition to be less preferred and less inclusive. So we do have some that are, I mean, I think there's arguments that you can still use the definition from the handbook that's being phased out because it's included in the way that the other handbook, but this just illustrates how complicated it is to just find the definition or refer, you know, even this is rather unhelpful if you actually want to know, okay, but is this thing in front of me? Does it meet the definition? Well, go look at 2 handbooks, one of which is expiring. So just very unhelpful in how technical this is. But I think that's where, Jackie, you have some ideas of how we would boil it down.
Right. So, so when we're thinking about the 2 types of sexual assault that are described and some of the language that has been used, we sort of come up with this idea that with respect to forcible sex acts, we're looking for a sex act that's directed against another person without the consent of that person, and including situations where the complainant or the alleged victim would be incapable of giving consent. And so that might be things like, you know, rape, sodomy, assault with an object, fondling, and there are more, as Jennifer mentioned, there are lots of definitions and descriptions of that conduct that, you know, you can go look to based on where the language of the statute leads us. But I've been sort of talking to people in training about using their own common sense understanding of these words, at least to get them to the point where they know that they need to go look. So good to keep in mind that there are, you know, there is further definition and help if you need it. And then with non-forcible conduct, we're talking about things like incest and statutory rape, which would be based on, you know, state law as far as whether a person is old enough to consent to sexual conduct. So that's what we're really talking about with respect to those definitions.
So fondling is another word that is included here that, you know, trying to define is not necessarily as straightforward as we might hope. The Department of Education has said that school systems do have latitude in sort of broadening or narrowing the definition of fondling in the commentary to the regs. And so we're looking generally, though, at touching of private parts for purposes of sexual gratification that is non-consensual. In those commentary, the department also explains that they're trying to capture sort of a broad range of sex offenses and leave recipients discretion to select particular definitions of things like consent or fondling to reflect the recipient's values and community standards, and then to adopt either a broader or narrower definition. So for instance, you could specify which body parts are considered private, or if the touching has to occur under or over clothing. We can have additional detail that's defined by the school.
So something to consider there is the discretion that's given is kind of described in terms of you can express your community values, but in a way, some of the communities that seek to be more supportive of complainants or more aggressive in addressing sexual might actually take the more restrictive definition so that conduct falls outside of Title IX. They can use their own preferred process for addressing it. So same with consent. One could take a what would traditionally be thought of as a supportive definition of consent, or just requiring great clarity, but now that's going to encapsulate all that conduct in the Title IX process, which someone might not, an institution might decide is not in the best interest of those students or victims. So anyways, just an interesting twist on, and it would take a lot of community communication, because someone might think, oh, you're narrowing the definition of consent in a way that's anti-victim, and actually you're narrowing it so that the victim has a less onerous process. So anyways, but back to fondling, what Kendra mentioned, something that I think we see sometimes is allegations of like a butt slap in the hallway, or something that might be more in the terms of hazing as far as the motivation. So there is the sexual gratification piece, and so we do think that you need to look at the context and whether there is any facts to indicate that it was done for sexual gratification, such that every butt slap would not necessarily fall under this definition, we don't think.
Yeah, and I think that one of the important things based on what Kendra and Jennifer are saying here is that you may have very different concepts of what conduct falls under sexual assault in a elementary school than in a university, both because in some ways you might take a narrower definition of what would fall under this definition under in an elementary school, recognizing the age and maturity of students and the desire to use teachable moments. But you might also have a broader definition of what is fondling, for instance, in the K-12 context, where you may say touching over the clothing, and I'm going to have a larger list of things that are considered private parts, because I'm recognizing that, you know, the boundaries are a little bit lower. So it really is a little bit of a paradox, thinking of, you know, where you're going to fall on a lot of these different terms.
Okay, so next we have domestic violence is the next one of our big five. So here's our definition of domestic violence. And again, this one may be more, I mean, it's somewhat clear, I think, even in this language and kind of what the common understanding of domestic violence. But if you go on, we have a kind of our boiled down and our examples of domestic violence that I'll let Kendra answer. Before, just one thing though, I did get a request recently. They said, you know, domestic violence, are we really going to be addressing that? And, you know, how often is that going to be meet the jurisdictional requirements? You know, I wonder, with so much learning happening in homes and remotely, and being a windows into literally people's homes, I think I can imagine circumstances where maybe domestic violence reports would be on the rise. But with that, I'll turn it over to Kendra.
Great. So if we kind of just break this down into a little bit more easy to understand language, we're talking about violence by a current or former romantic or intimate partner. And examples of who that might be are listed here. We do want to note, you know, we're talking about a romantic or intimate partner, so something like roommates would not fall in this category if there's not also a more romantic relationship. So people cohabitating must be either current or former spouses or in that intimate relationship for that to be included in domestic violence. It seems, you know, in general under Title IX, we define, you know, all the definitions start with conduct on the basis of sex. And so this is a little bit different in that, you know, the violence doesn't have to be, we don't think necessarily on the basis of sex, because that relationship piece encapsulates that basis of sex part of the definition. So that because of the relationship between the parties, then it falls under that requirement. So the next thing we're going to talk about is dating violence. And here is our statutory definition. Again, this, like the domestic violence, is a little bit easier to understand. Talking about violence when there's a social romantic relationship between the two parties. And when we're talking about that relationship, we can show it looking at considering the length of the relationship, the type, the frequency of interaction of the people involved in the relationship. You know, obviously a dating relationship is a little bit harder to define. Certainly in high school and college, you know, these things can be a little bit fluid and difficult even for the people involved. So breaking it down a little bit here. We have violence and threats of violence committed by a person who is or has been in a social relationship or of a romantic or intimate nature with the victim. We do want to consider the complainant's description of that relationship as how we view this and start to analyze the question. It can include sexual, physical, emotional, or psychological violence or threats. And so that's important to keep in mind, is that sort of broader scope that includes not just physical violence, but sexual and emotional and psychological violence as well.
Right, and again, here with dating violence, just like with domestic violence, you know, the nature of the relationship means that we're not as concerned about whether the specific conduct itself can be described as being based on sex. That's usually, as Kendra mentioned, a prerequisite is that we're looking for some sex-based conduct. But here, again, we're not saying that that element is gone. It's always a part of the Title IX analysis, but because of the nature of the relationship, like with domestic violence, we're assuming that violence that occurs within that relationship is based on sex. And then our final of the Title IX Big Five is stalking. And we have the definition here as engaging in a course of conduct directed at a specific person that would cause that person to fear for their safety or the safety of another, or suffer substantial emotional distress. And so again, we've broken that down here for you in just a little bit simpler terms. And Jennifer, I know you've got some thoughts on this one too.
Oops, sorry. On stalking, so for purposes of this definition, we're looking at a course of conduct that means two or more acts, but you know, it could be direct, indirect, through third parties, by any action. So it's really broad. Like when we're looking for those two different events, be holistic in what you're considering more than one incident. And the other thing is a reasonable person standard. Jackie, both of us have gotten a lot of questions throughout all of our training about who is this reasonable person, you know, is it, and a lot of questions about, is it the white middle-aged man that gets to decide everything for us? No, you know, that's not, it's reasonable in light of that person's circumstances, which could include things like the person's race, age, gender. You know, we're not imposing what a 50-year-old white man thinks about every scenario. That's my take a summary of the law. Jackie, I don't know if you have a different feel about that reasonable person standard, which I think really kind of rubs people the wrong way in light of a lot of our concerns.
Yeah,
right
no,
now.
I think it's really important to keep in mind that if you're dealing with a person who's 5 years old, you're going to be looking at what a reasonable 5-year-old would think. And if you're dealing with someone who has a specific gender identity, that is an issue, that you're going to consider that as in thinking of the reasonable person. And then also another important thing about this stalking definition is that substantial emotional distress does not require that the person have had to go to the hospital, receive professional treatment or counseling or anything of that sort.
Yeah, and I'll just, you know, Jennifer was highlighting that we need at least 2 acts for it to be stalking, and we can look pretty broadly to think about what those acts are. For all of the other Title IX Big Five, it can happen just once. Stalking is the one where you need, you know, at least 2 incidents. So kind of a little bit more like your hostile environment analysis, but not, it's different, but you know, here we do need at least 2 acts. The other thing that I would want to flag is going back to that definition that Jackie and I were talking about with it needing to have some sort of basis in sex, so some sort of sex-based conduct. I think if we had, you know, a heterosexual male stalking another heterosexual male, maybe they're an athlete or someone they admire or are obsessed with, there might not be anything sexual about it. The conduct might not have any sex relationship, and so that probably would not fall under Title IX. We would need to look for some sort of sex-based conduct or motivation for it to get pulled into our definition under Title IX.
And you can see from all of these intricacies and places where we're saying we think that this would fall in or would fall out, these are issues that we're all working through in real time. You're going to want to make sure that your Title IX coordinator is regularly in contact with your legal counsel to make sure that you have the understanding of what the current definitions and the current understanding of those definitions are. And then remember, for everything else, you're going to want to make sure that you're doing your hostile environment analysis, which we remind you of what that looks like here. All right, we are at 1:03, and it doesn't look like we have any pending questions. So we'll say thank you to everyone for joining us. We will look forward to seeing you the first Tuesday of the month. I will say that the first Tuesday of November is a rather important date. It is election day, so we almost certainly are not going to have this meetup on that week. We'll probably do it the next Tuesday just for that 1 month, but regularly you should mark your calendars for the first Tuesday of the month, and we'll look forward to you joining us then. Thanks, Jennifer and Kendra, and thank you everyone for joining us. Have a great day and take care.